All right. It is 10:03, so we are going to go ahead and get started. We might have some folks joining us throughout, and that is okay. Great. So again, thank you all for being here. This is a follow-up to another webinar that we recently did regarding the recent IFR ruling. So in this session, we're going to answer some questions and that we will do kind of a quick review of the first webinar, and then we will answer some questions, a combination of questions that we've received and questions that we anticipate folks might have about this. And we'll have some time where you all can ask additional questions throughout the webinar. So we'll talk a little bit about how you can do that in just a moment. So first, I'd like to introduce everyone who is here. So I'm Dr. Nicole Yates. I will be moderating the conversation today. I'm a senior consultant and co-owner with Keen Independent Research. And our primary presenters today, first we have Dave Keen. He is the founding principal of Keen Independent Research, which is a national economic and policy research firm. Dave has extensive experience helping state DOTs, transit agencies, and airports nationally implement the federal DBE program. This includes doing contracting availability and disparity studies. He's also authored various transportation research board studies that have looked at enhancing the effectiveness of the DBE program. And he has often served as an expert witness in the successful defense of contract equity programs, including having worked with Mara Rosales to defend the California Department of Transportation's DBE program. So that's Dave. Then we have Mara Rosales, managing partner for Rosales Law Partners. And Mara, prior to opening Rosales Law Partners, was San Francisco San Francisco International Airport's general counsel for over a decade. Also spent 9 years as a San Francisco deputy city attorney in the government law division. Mara has extensive experience in airport law and government law. She specialized in equal protection in public contracting agents, in public contracting agencies. Mara has authored and defended several business contracting programs in the Ninth Circuit. And she has also she's been the lead outside counsel, successfully representing California Department of Transportation. And has authored and defended several contracting programs, including the San Francisco Minority Women Local Business Enterprise Ordinance. So that's Dave and Mara, and they will be giving you a quick review of what we talked about in this first webinar. So before that, we will have a few opportunities throughout this presentation for folks to give input, for you to ask additional questions or make comments. So a couple things to note there. First off is that this session is recorded. It will be posted to YouTube. Um, and so we will, when reading out any questions that you do submit, we will encourage you to be anonymous there and not use any identifying information. But as I read them out, I will read them out anonymously anyway. So none of your specific agencies or titles will be disclosed, even if you choose to provide them. And so are grouping these questions kind of in categories. So we'll pause after we've gone through a couple of different topics, and you'll have the opportunity to ask additional questions. There is a Q&A function at the bottom of your screen there. There should be a little Q&A, like a little icon there. It says Q&A. And you can click on that and submit a question there or comment to the panel. And I will read that question aloud. And again, we'll remove any identifying information if you choose to include it. So again, we'll stop at a few different times during this, and you'll have opportunities to do that. So once we get to those points, we will pause for your questions and comments. So now I will turn it over to Mara and Dave to give a recap of what we talked about in the first webinar.
Well, thank you very much. And Mara and I really appreciate all the attendees from the first session we had. That was very well attended, and many of you came back. So we thank you for that. Um, so the first couple slides are things that you've seen, but we got to add another image to the first slide here, the December 1st FAQs 2 from USDOT. So the key events were October 3rd, where we had the IFR published. The first set of FAQs came out on October 21st, 24th, and then we had the second set of FAQs. We don't know if there will be anything more. When we talk to our clients and others around the country, we get the sense of anticipation that there's got to be more. There's got to be more clarity here. And I think our advice is you have enough to start acting and doing things and moving forward, and time is the enemy here. So the unknown future actions for Mara and me mean exactly that. We don't know that you're going to have anything more to go on, and so we think, especially with the December 1st FAQs, which we're going to talk about today, you got enough to go on, and the intention of today's webinar is to answer some of the remaining questions that might be a stumbling block, might keep you from acting both on the reevaluation part of this or the other requirements, and get everybody going as quickly as possible. The reason you want to do this is you cannot start DBE contract goals, you cannot restart programs or start a newly crafted program. Perhaps you want to have small business contract goals in your program in the future, but you don't have them now. All of that needs to happen after the reevaluation is complete, and the regulations require that to be done as soon as practicable. Along with that, having a new DBE program plan and new overall DBE goals, including the DBE neutral projection, and if there is any portion that will be DBE conscious in your future operation of the program. And that all is under the category as soon as practicable. It does not fit the standard dates that you might be submitting a goal. We assume that those will remain in place, that once you get a new goal submitted as soon as practicable, maybe in the next 3 or 4 months, or maybe even sooner, that if you have a fall 2026 deadline for your standard date for your 3-year goal, that will still be in place. That won't go away. Maybe you'll just submit your new goal that you would submit maybe in March or April of 2026. Maybe you'll submit that again. But anyway, time is of the essence, and you can only really restart the program in a meaningful way after the other steps are completed. So the other steps are, just let's review: recertification, a new overall DBE goal if you're a recipient, and a new DBE program plan. Mara, I miss anything here?
No, that's what it was, and that's what it is right now. Yes.
Okay, another repeat slide from the first webinar is this reevaluation process. This is about home state DBEs. There seems to be some confusion about this among certifiers, but this is about home state, and that you are decertifying any DBEs in the home state that do not reapply for certification and make it through recertification, and any of the DBEs in the home state that have reapplied and make it through your evaluation of the personal narrative and the personal net worth, revised personal net worth statement or updated statement. If they make it through, then they are recertified. And then when you're done with that, you can notify USDOT, or you must notify USDOT. And then there's a different process for the interstate applications, but it really starts with the home states. All the way through this webinar, just like the first one, we're meaning ACDBEs when we say DBEs. So it's both DBEs and ACDBEs. And we have some questions about personal narrative that we'll discuss, but just another reminder slide from the first webinar. This is about specific instances of economic hardships, systemic barriers, and denied opportunities that may have impeded the owner's progress or success in, and then these categories. So education, employment, business, financing is so emphasized in the IFR that we have listed as a fourth bullet there. And you need to say, not only what happened, but also the so what. And the comparison is where you treated the same as others compared to non-disadvantaged persons is the language from the IFR. So that's just a reminder of what goes into the personal narrative. There's a lot of nuance and probably in terms of what to work out and how to do this, this is where we will spend a lot of time in the next 45 minutes. So that was racing through an hour-long webinar in just a few minutes. We want to get the first question. Can we set a deadline for completion of the reevaluation? And our answer is based on the FAQs from December 1st, which had some clarity. There was some language about you can't set a deadline, and then there was language in the FAQs that said what you can do is set a date by which currently certified DBE should submit the required documentation. So as long as you don't use the word deadline and you say, here's the date by which current DBEs should submit the required documentation, it appears that you're in line with what is in the IFR. So once that date passes and the reevaluation has been, that consideration of what the applications say has been done, for those that have submitted something by that date, then you say to USDOT, reevaluation is complete. This required some close reading of what was both in the original AFR and in the FAQs, but that is our answer to this. So right now, we don't see state UCPs setting deadlines, which is good, but we don't see a lot of information about, oh, when do you need to do this by if you're a DBE? We reviewed the 50 states plus district in the District of Columbia and Puerto Rico, and we have found that only a few are currently accepting certifications. So we may, in part, we don't see these dates by which DBE should be complying. We don't see that in part because there's not been a lot of progress across the country in getting this reevaluation process started. In some states they have, and then we're not seeing those dates to comply by in those states yet. So we think that that's a necessary part of the reevaluation process. Otherwise, how would you defend not looking at a DBE in their application if they came in June or August of next year, for example? There needs to be some kind of communication to the DBEs of your expectations if you're a certifier about when they need to do something. Mara, what else do you have to say about this?
Yeah, what I would just kind of maybe just as a distinction, a deadline is, the obvious language, right? A natural conclusion where no one else can be heard or can submit an application. So I think that's what the original intent was. But for what I call administrative convenience, thankfully the DOT is recognizing that you can't manage your DBE program and all the bells and whistles that are required if you don't have some level of finality for this reevaluation. So I think that's what this date is. And the clarification points out that if someone comes in, a DBE comes in after the date, they need to be reevaluated, but they cannot be counted as a DBE under the new program. So this is good news.
Second question is, can you help them? And we talked about this in the first webinar. It is clear from our reading of the IFR that USDOT anticipates assistance to DBEs in the reevaluation process. Again, talking with different groups around the country, we get a different sense of how much help is going to be given by the certifiers or by the recipients. And we've heard from some certifiers and recipients that they're trying to avoid help at all. And we don't think that that's correct. We don't think that there's anything in the IFR that would justify that. In fact, it's the opposite. So some of the language out of the IFR that we showed in the first webinar that we're showing again is when they're working out on the IFR, kind of what the implications for certifiers is, are they this language is in the IFR. So there's anticipation that would require certifying agencies to spend time following up with applicants and guiding them through the application as they go through the recertification process, which also means reevaluation. Um, and there will be an increase in the workload and support services given to DBEs. So it's the opposite of what we need to be really hands off. No, the IFR anticipates that certifiers will either directly or indirectly be providing some assistance. And in the face of this, Key Independent developed some proposals that we have out to certifiers to actually have the certifiers or recipients pay us to help the DBEs do listening sessions where they would be able to get through the blank page problem and have a draft of a personal narrative with that assistance that would be paid by public agencies rather than by the DBEs themselves. That's a way to expedite their submissions of personal narratives and perhaps improve the kind of the compliance that they have in what's in a personal narrative. So it does not, spend a whole lot of time talking about race and gender. It actually talks about the things that are in the IFR. So, and we've been talking to some of our current and recent clients about doing this to get through the reevaluation process quickly. And from the point of view of the DBEs, we think that many DBEs will not be able to put a personal narrative together or get past the blank page problem without some kind of more direct assistance than what most agencies are providing right now. So question one is, can you set a deadline? Technically, no, but you can set a date. Question number two, can you help DBEs? And the answer clearly is yes. And we find these two questions and our answers probably to be the most different than what we're finding for the average state around the country. So that's a reason we wanted to give you a chance to either debate this or ask us follow-up questions.
Okay. So yes, the reminders there, you can use that Q&A feature to submit a question or comment. I see that there are a few coming in here. And so I will go ahead and read those, but as you have them, please submit any additional questions or comments related to these two topics that we just discussed. So first off, my agency has a DBE program, but we are not a certifying agency. Are we more or less on hold until the recertification process is well underway or complete?
Yes and no. You still need to do, I'll go back. I got a slide for this. Some of the things on this first slide are your responsibility as the recipient. So look at this as soon as practicable. You can be helping DBEs in your home state get recertified and helping them providing assistance directly or indirectly to get personal narratives in. There has been technical assistance given in the past around the personal net worth statements. So to the extent that those DBEs might need help with that again, make sure that that type of assistance continues to be available. So that's one thing you can do even if you're not the direct certifier. The other two things are not the certifier's responsibility, it's the recipient's responsibility. Is submit new overall DBE goal, getting ready to do that. We're going to talk, that's one of the questions, and there's things that you could be doing now to get ready to do that, and developing the new DBE program plan. Same answer. You need to wait until the reevaluation process is complete to submit it, but you do not need to wait to start. And waiting to start that until the reevaluation is complete, you've actually created a new box that is going to slow you down to get to the end goal of being able to get back to whatever program you have. And you don't want to do that. You want to have, ideally, the reevaluation is done on, a Monday, and your goal and your program plan are submitted the next day on a Tuesday. And we're going to talk about how you make that happen. We don't see necessarily recipients moving quickly to do that, and we want to make sure that we've given you all the information so you can make good decisions around, hey, do you want to start that now, or is it a good idea to start it now? And we think that's yes.
All right, thank you. We have three more on these topics. So, with this new IFR rule for DBE, are transit agencies required or compulsory to have disparity studies with regard to contract capacity for a new DBE triennial goal methodology? Or can agencies update their already submitted DBE triennial methodology to reflect the new IFR rule or requirement without conducting disparity studies?
Well, I don't want to eliminate the moment for Mara Rosales to say, do a disparity study. It's a really good idea. So, Mara, you want to get that out of the way?
Yes, this question or this comment came up in the last session. My recommendation as counsel to public agencies for decades now, and especially in light of the changes in the law that are, in my opinion, somewhat being undermined by the Department of Justice. My recommendation is to have a disparity study supporting any program. The manner in which this IFR changes the rules, one could argue that they're advocating or they're requiring a race neutral approach rather than a race conscious approach. I take the position that the race neutral approach that's being advanced here is a component, like step one, if you will, to an eventual possible race conscious approach. And so therefore a disparity study is the best tool available. Definitely you need to consider capacity of the businesses in any studies. That's not just required by the IFR, but that's required by best practices and, in my opinion, by the current state of equal protection law. So the answer is it's not required, highly recommended. It's just best to do it on the front end rather than having to do it in the eventual back end in the event that it's required.
And we have more on what it is, what is it about a disparity study or some similar type of study that will help you in later in our hour. Back to you, Nikki.
All right, thank you. Okay, we've got four more. This comment says, well, let's be clear. It's not that we don't want to help. It's that it would be impossible for states who have one or two certifiers to help all several hundred firms work on their personal narrative. We're not tutors or English teachers. We're certifiers.
A quick answer to
Understand.
that. We anticipated that being an issue because you want to do this fast. You're not going to do this over 12 months. You want to do this over a couple months. That's why we've written proposals to be able to offer assistance to all home state DBEs in whatever state that we're talking with them about. So if you're interested in that, contact us. This is what we think is a very reasonable cost because there are cost efficiencies to doing it this way rather than having DBEs pay for it themselves. And because time is of the essence, you can get this done quicker. You can have a date that's more aggressive because you're offering this assistance. Many states have mega projects or very large projects. They are reluctant to have those projects go out without goals. And for a very, small fraction of the total contracting volume and the importance of the DBE program, we think the cost of the assistance through a third party, whether it's us or somebody else, is there's a rounding error. It's so cheap compared to what it's costing to either delay those projects or to put the implications of putting out those projects out without a goal. Time is the enemy, and this is a way to move fast, as well as it being fair to DBEs because they didn't ask for this, and this is a big lift. So That's our answer there. Next, Nikki.
Thank you. If the firm does not meet the time frame provided, do we automatically get decertified or is there a grace period?
That's a Mara question.
I'm assuming this question is based on the notice has gone out, obviously, for submitting the personal narrative and other forms or information for the reevaluation. So I'm understanding the question to say someone was given notice and they missed the deadline, or they missed the date. With that understanding, and please clarify if I'm misunderstanding it, I think it's up to the agency. This would be one of these administrative convenience, I think, decisions. What happens there? So you have the folks that are notified and they come in. They are the folks that have tried to come in, but they don't complete. And then you have the folks that don't respond. I would say you need to give an opportunity to everyone to submit. But if they miss the date, I would advocate for having a process for what happens in that circumstance, but not be punitive. So do not result in a denial of the certification. Now, do you
So
have a view?
yeah, and I think the IFR gives the certifiers the discretion to say, you missed the date, you're decertified. So any process is really would be in addition to what's in the IFR, maybe more generous than what's in the IFR if I'm understanding your response correctly.
Okay. Thank you. All right, we've got a few more here. A comment that was related to this conversation that just came in. It says they will remain ineligible to participate in the DBE program. Um,
Yes.
Yes. Okay. Great. Okay. So a couple more, and then we've got a few more topics to go through. Really appreciating your questions, but we'll move on after these three here. My state is telling its partners that it is working with USDOT to transition the state entirely away from the DBE/ACDBE programs. Since we are under the state's DOT, what does that mean for us certifiers? We have multiple UCPs throughout the state, and we were planning to do the reevaluations, but now we're unsure if we should move forward with that process.
Any questions that say, my state is telling me to break the law, to not comply with federal regulations that will put my federal funding at risk? I want to hand those to Mara.
I'm sorry. Can you repeat the question? There
So
was
they
Yes.
say,
that I captured.
this is a wild one.
Yes, yes. It says basically the state's telling its partners that they're working with USDOT to transition the state entirely away from DBE/ACDBE programs, and so they're asking that for them as certifiers under the state DOT, what does that mean for them?
Well, the simple answer, since we're on the record, is the law is the law, that as long as the law has not changed, it must be complied with. I don't know uh, whether the DOT, frankly, has, as a regulatory body and as part of the executive branch, has the authority to exempt a state DOT from what is a congressionally required program. So I'm going to stop there because I don't want to say much more on the record, but my sense is I agree with Dave that the state must follow, and all the subrecipients must follow the federal requirements until further notice. That's all I can say at this point because it would, in my opinion, requires a congressional action to permit that.
Thank you, Mara. Okay. By assisting a firm with their personal narrative, aren't certifiers creating the potential for liability and or bias?
We anticipated that. That's why we think having a third party provide the assistance that we have proposed to a few states is to perform listening sessions where we help the individual DBE tell their story, and then we get that story on paper and then we anticipate that there's liability and questions there, and we've handled them because it's their story. It's not anybody else's story. It's certainly not the state's story. So having a little bit of distance there could be helpful. So that is our answer to that question. There may be other perfectly legitimate ways to handle that. And there's a long history of providing technical assistance around certification. It's just because there's this personal narrative component that makes it even more difficult now. So we understand the question. We think there's at least one way, which is to contract this out. You probably don't have enough people to do this anyway in a short amount of time, and that would be the other reason to contract it out.
Thanks, Dave. Okay, and then what tools or resources are available to support firms seeking recertification, particularly in preparing a strong and successful narrative? Are there recommended websites, guidance documents, or FAQs?
We see this state
Yes.
by state, and the 8A program, the SBA, had a lot of assistance and had this really worked out because they were ahead in the personal narrative game. And they took all of that down so that that's not on their website anymore. We don't know if that's anything that SBA would stand behind, which is unfortunate. So it's hard to interpret that taking it down. We've seen a few states actually put some examples of what would go into a personal narrative up. And in some cases, it's just kind of restating what the IFR states. So there's not enough guidance. There's not enough information out there for DBEs in our opinion. And the natural go-to place would have been the SBA around the 8A certification process, and that's just gone. And we don't want to recommend that. We have all those materials, but we don't want to recommend that if that also took into account race and gender in a way that the IFR appears not to. So that would be another reason that the 8A program guidance wouldn't be useful. Not a very good answer here.
Yeah, and I would add that in the last webinar, as a similar question I think came up, or I made a similar comment that some of the guidance can be found either in the SBA program or the Title VI regulations, and there's been just a very recent change in the last few days on the Title VI regulations. I have not had my team has not had a chance to do a deep dive on those. So yeah, it's a great question, and we're still sorting it out. Happy to share that information when we have better clarity, but a natural place would be, of course, the Title VI regulations as well.
Thank you, Mara and Dave. Okay, we do have a couple additional questions, comments that came in, but I'm going to tag those on to the end so we can move on. We've got a few more topics to cover. So thank you all very much for your questions. We're going to continue at this time.
How much evidence of disadvantage in the personal narrative is enough? So I will tell you what I know and then hand it to our expert, Mara Rosales. But we did get in the IFR and in the FAQs that there is some examples of topics, but they're not mandatory topics. And that was made clear in the December 1st FAQs that you don't need to have evidence in each category. Like if somebody skips over education, that's fine. And you have to look at this holistically. It's the preponderance of the evidence standard. And then basically I'll hand this to Mara, noting that you start with a scale that's level and whole personal narrative and evaluation process is does that DBE meet the standard of having enough evidence to be able to conclude that they are socially disadvantaged using the legal standard in the IFR? Mara?
So we talked about this also in the first webinar about what does it take essentially to have a sufficient personal narrative that demonstrates this evidence of social disadvantage. And as Dave said, there is guidance in the the DOT has provided. And again, you don't have to start. I've been asked this question. Do we have to start from when I was 4 years old? The answer is no. But what I'm advising is, and this will require each individual business owner to really think carefully and deeply about their personal experience, mainly because to show what is needed, you really have to kind of do an inward review of your life and in these various categories with the concept of a social disadvantage in your mind. And that is either in the education context or in the education experience that you've had, the employment, in the business realm, access to capital. There has to be, in my opinion, if you can identify, as if the business owner can identify and demonstrate to the certifier as concisely as possible. And frankly, I've done this for myself because my firm is a certified DBE. So I can tell you that it requires specificity and a need for the individual to be concise. And I would recommend not one, even though one example or one incident or one illustration of a disadvantage experience in one's lifetime, it could be sufficient. It's best to think through and to demonstrate as the business person in each of these categories if it applies. Um, how does one avoid, if you will, or not focus, perhaps is a better way of saying it, the a disadvantage based on race or sex. I have advised, and I continue to advise, that one's personal experience, in my case, as an example, as a Latina of immigrant parents born in California, that's part of my history, and so my life story, and to the extent that is something that one needs to show, should be shown again with specificity. But the point here is not to neither the certifier looking to this kind of evidence or the presenter, the business owner, showing a conclusion of disadvantages based on race or sex, because that's what the guideline and the requirements is today, that you cannot base your disadvantage or social disadvantage based on race or sex. So when the individual has presented, hopefully, as much of their personal lived experience in writing concisely, then the certifier needs to weigh that from an objective standpoint. And this is where the preponderance of the evidence scale comes in. As Dave said, you start with the scale being balanced. And so the preponderance standard is that is it more likely than not that the individual is expressing or demonstrating social disadvantagedness. It's a case-by-case analysis. I know that's not good to hear as a certifier. You need to be certainly objective in evaluating that standard and whether it's met. I encourage you to seek, obviously, legal counsel if there's any concern or need other guidance. But the standard of preponderance of the evidence, in my opinion, is basically the same throughout the states. And that's where the scale, this scale that we are seeing here, is tipping, in favor of a conclusion, an objective conclusion, that there has been social disadvantage demonstrated by the individual. So that's not a straight answer because this is nuanced, unfortunately. It requires you a little bit to be an attorney or have some kind of legal thinking in approaching this, but that's the kind of evidence. It's not a quantum of evidence. It's a demonstration of the evidence. Like I said, one experience can be sufficient.
Okay, so a certifier gets a personal narrative that has evidence of disadvantage that's not related to race and gender, and then discussions in the personal narrative that is directly related to race or gender. So Mara and I have talked about this. It appears that you can disregard the race and gender parts of it and not throw it out. So going back to the scale, um, if the if a personal narrative is prepared in a way that didn't follow the IFR completely, and it said, okay, let me tell you about me being discriminated based on my race or gender, and therefore I am socially disadvantaged. And then they include some other things like I grew up poor and I didn't have the same advantages as people who didn't grow up poor, and here's how it affected my education and my employment and my getting into business and being successful in business and has lasting effects today. Say they have both. Our advice is do not throw out that application. And using the scale analogy, if they have some things that really aren't in compliance with the IFR, it doesn't go on the left-hand side of the scale as counting against them. We're recommending that the certifier simply ignore those statements. My analogy is you print out the personal narrative and you're circling what's relevant, and you don't need to count against anybody things that maybe are talking about race and gender that you are not going to consider. You don't need to count that against them. They can just be not counted at all. Mara, did I get that right?
Yes, I mean, if there's evidence that is clearly not consistent with the requirements, you can ignore it as a certifier and then and treat it as though this is what judges do, treat it as though it's not part of the evaluation of the evidentiary evaluation. So yes.
Okay, we're going to pause here. We are not going to forget the other questions that came in our first pause. Nikki's keeping track of those, but any follow-up questions about these two overall questions?
Yes, correct. We will follow up with those as well. But yes, I have a couple of questions that came in that I will read, and then I'll get to those two, and then we can get on to the next topic here. So, first is must an agency wait for certifying office slash certifier until it has completely recertified and decertified all DBEs in its state prior to redoing the agency's program and goal?
Quickly, you want them to be submitted together. The USDOT will not act by the IFR. It appears like they won't act on the review of the plan or the goal until the reevaluation is complete. And you may need some information from the final reevaluation, especially when you're looking at the goal, and you need information from the goal when you're putting the plan together. My advice is reevaluate and notify USDOT on a Monday, and by Tuesday you've submitted the plan and the goal, and we have worked out ways that you would be able to do that. And that will require starting now with the goal and with the plan, but not submitting until the UCP has notified USDOT that this reevaluation is complete.
Thank you. And the next one, by the regulations referring to a legal standard, a preponderance of evidence, does that put the decision makers at risk of lawsuits? We're not attorneys or judges trying to determine this.
Mara?
Um, I would say no, but again, that's with a caveat. Uh, I would say no. I think that this is an administrative process, that if you state whatever as a certifier, your basis on the record, and you, let's say, deny certification to a DBE, then that DBE under the regulations can appeal that to the USDOT and raise whatever questions or concerns or issues. And if one of the concerns that are raised is that the certifier did not properly assess this preponderance of the evidence standard, that's something for the USDOT on appeal. And their attorneys are the ones who, in my experience, their attorneys are the ones who handle many of those appeals, if not all of them. So I would say no to that. I don't think it exposes state actors to liability for making an administrative decision. Now, if there's an intentional act of discrimination, that might be a different question under state law or federal law.
Thank you. All right, let's move on.
Okay, what do you need to do a new overall DBE goal, and when do you need to do that? So we've had a couple questions about this already. So very quickly, Uh, we think the day after or later in the afternoon when you've notified you or the certifying agencies from that state have notified USDOT that the reevaluation is complete. Um, you should not wait to start this until then, and you should not wait until to start the new overall goal until you have that on your calendar in terms of the normal dates. So whatever you were planning to do before the October 3rd release of the IFR, say that was in August of 2026 that you wanted to submit a goal for review and have in place by October of that year for the next three federal fiscal years, or maybe it was a 2027 date, or maybe it was 2028. Maybe you just submitted something. That doesn't matter. You need a new overall DBE goal. And again, we've had some questions about this among the clients that we have, and we've been very clear based on reading of the IFR that in addition to those normal dates, there is a special date, and that's along with the reevaluation, you need the overall goal because now think of it from the USDOT's point of view. They've changed the rules of the game. So for you to successfully operate the program, you need to have a goal that complies with the new rules in place and a new plan that complies with the new rules before you can go back to DBE contract goals. They've been very clear about that. So that is the answer to that question. And what to do if relatively few DBEs go through reevaluation, which we think is possible. We have concerns about. Can the new overall DBE goal consider potential DBEs? So this gets into the setting of a goal. So prior to October 3rd, you could consider potential DBEs. That would have been prior to October 3rd, minority and women-owned firms that appear to be eligible for DBE certification, but are not currently DBE certified and didn't try for certification and were never denied. It's just firms that have never gotten around to applying. The answer is you could do that. In fact, the guidance that was issued said, yeah, you should strongly consider doing that. That's more than okay. So there is nothing in the IFR that changes that. And they actually answered that in the FAQ that you can consider those firms that could be potentially DBE certified under the new rule, but are not currently certified. And how do you do that? Well, you can't just count minority and women-owned firms. You have to do some additional things. But the simple answer is yes, you can consider potential DBEs. What's the implication for your goal? That it might be higher than it would be if you just count the DBEs that make it through the reevaluation process, that both take the time and energy to get recertified or apply for certification and are positively evaluated, are certified through that process. So this is almost a two-part question because I'll go to how do you set an overall DBE goal? And one of the questions that we had earlier was, what's the role of a disparity study? So can you use a recent disparity study to set an overall DBE goal? No, if it does not consider firm capacity. So what is firm capacity? So the way we do this in key independent disparity studies is we have data on the size and type and location of, say, a state DOT's contracts or expected contracts. We know what they're for, we know how big they are, if they're a prime contractor or subcontract, and we know what part of the state they're in. Then we survey firms in the relevant industries and get data from them about what type of work do they do, where in the state do they work, do they work as a prime or as a sub or both? And then importantly, what size of projects do you bid on? And that gets at capacity. And that's been upheld in the courts as a measure of capacity, which is often, we see some court decisions that require this as well. So that's our answer to it. That's been accepted in the courts. We're one of the few firms that do that in our disparity studies. So if you don't have some analysis of firm capacity in a disparity study, the answer is no, that disparity study as is not useful. However, the disparity study that has it could be. However, you still need more information about the broader set of firms that could be potential DBEs. So we're doing this disparity study for a state right now, where we are asking in our availability survey question, not just the standard questions about the race and gender of the business owner, but also explaining what DBE certification is, and then asking the respondent, the business owner or manager, do you think your firm would qualify and would be interested in DBE certification? And we're seeing results from that question that make a lot of sense. So that's a current disparity study. What we have planned to do is for some recent disparity studies is go back to supplement that data in an availability survey by recontacting those businesses, those small businesses that appear that they could qualify based on size, and explaining what DBE certification is and asking them if they would be interested and would their firm qualify for DBE certification. So a lot to ponder there. So let's get to some follow-up questions.
All right, thanks, Dave. We've got three that I will read out, and then we will go on to the next topic. First, how do you submit a goal methodology the day after you notify USDOT of the completion of the reevaluation if you must complete the methodology utilizing the updated database of all DBEs that were recertified? Also, there's a 30-day comment period.
Yeah, so it's probably not literally the day after, but you can be keeping track of who has been recertified and sharing that information. Um, and if you're using information on potential DBEs, that's information you can go out and collect now. So for this client that I just mentioned, they won't, when we're done with their availability survey, they won't be ready to submit a new overall DBE goal. They'll need to wait until the reevaluation is done, but they can use their database on potential DBEs that has capacity information in it. And we are going to calculate a goal for them and have that be ready even before the reevaluation is complete. Once the reevaluation is complete, we can go see if we have any additional information that's important to consider in those calculations. If there are, we're set up to instantly respond. It takes minutes to update the goal. And then the question would be, when should they start public communications about this? And I think what we will set up for them is do that early, and it may be a preliminary goal that could be adjusted after the reevaluation is complete. So they could be ready immediately after the reevaluation process is closed.
Thank
Nikki, did
you.
that make any
Okay.
sense?
I think that made sense.
Okay,
Yes.
good.
Made sense to me. If it didn't, we could ask for clarification. Okay. Let's see. We've got what is involved to get a new goal? Is it the triennial process?
It's very much like the triennial process. We believe they simplified some of the public comment and public review part of it. So that's in the IFR. It's a little bit different than the triennial process, but it's a goal. It needs to, we think it should consider capacity. It should consider if there's going to be some changes in contracting, if there's a big new project that's coming up that's unusual, being able to consider that. And then it's the projection of what's neutral, what's race and gender conscious, or I'm sorry, DBE conscious part of it. And that needs to be in the goal. So it's very much tied to the process that existed before October 3rd. It's the definitions of DBE that is the major change. And the fact that you need to do a kind of a midterm goal, a goal that's outside of the 3-year process. And that needs to be done really immediately, as soon as practicable.
Thank you. And last one for this section. With a personal narrative requirement, how could you possibly identify potential firms? Would you just look at size?
we have conversations with them. So it's firms that appear to meet the size standard, but then explaining what that they would need to meet a definition of social disadvantage, and that there is an application process for DBEs, and then what you get out of being DBE certified. Our experiment with not experiment, a real case scenario with our one client in our availability survey where we've talked with hundreds and hundreds of firms, um, the answers are making sense to us. We're not finding a surprise or kind of understanding this. Now, it may be that some of the firms don't proceed with certification, and then other firms that either we didn't talk to or said no, they weren't interested, end up applying. It doesn't matter for purposes of overall goal setting because that issue took place, was there in the old way of considering potential DBEs when you were just looking at minority women-owned firms, because not all of them would be certified either. And that appeared to be goals that were approved by USDOT. Again, the very surprisingly little in the regulations and the guidance has been changed. The big change is this definition. So using things that are tried and true that we've been successful with in the past and other in the states and recipients have, seems to be the path forward, but finding new ways to apply this new definition.
All right, thanks, Dave. So we are about on time, but here, so we do have a few additional topics, a couple topics to cover. So we'll go ahead, Dave and Mara, have you all go through those. And for folks that have additional questions, please do provide them. And we will be sure to follow up with you all afterwards to provide answers for those. But we wanted to get through these couple additional topics to give you some of that information before you go here. So
Yeah,
thank you all. And
and we'll go a few minutes over time,
yes.
but we'll do these very quickly. Can you do just the contract goals while you're waiting on reevaluation? Yes, if it's part of your program plan. No, if it's not. And this might be a good idea for a new DBE program plan, but you can't preempt the process and put them in place now for your federally funded contracts or USDOT funded contracts. You've got to wait. Mara, I think this is the answer that you and I worked out. And then what do you do on your other programs that don't use USDOT funds? Can you continue with your programs? And the answer is yes, the IFR did not affect those programs. And all of the constraints around those programs, legal issues, everything else that existed on October 2nd, those didn't go away or change on October 3rd. The statement of the law in the IFR might you might read that into affecting say, your state MBE program or local MBE WBE program. And we urge you to consider that, but not use that as the definitive statement of what the law is around any contract equity programs. That's the USDOT position, or the current USDOJ position. That's actually there's some legal arguments that may be not what they mentioned in their preamble to the IFR. Mara, did I say that delicately?
Yes, and I would say just more directly that if it's an MWBE program, it's best to meet the strict scrutiny standard as set forth in the Croson case. It's been on the books now for at least 30, since 1985 or 89. That is the standard. It was the case that was referenced by the U.S. Supreme Court without change in the Harvard case. So yes, the law is still the law on Adarand and Croson are still the Supreme Court cases that govern the MWBE and I would say the DBE program as well. SBE programs are subject to race neutral analysis.
Okay, so let's get any more follow-up questions on those two points. And that is it for our webinar today in terms of prepared questions and answers. But we wanted to get through the rest of these and then make sure everybody has their issues out and considered.
Great. Okay. So question we have related to these. With this new IFR rule for DBE, are transit agencies required or compulsory to have uh, required or compulsory to have disparity studies with regard to contract capacity for a new DBE triennial goal methodology, or can agencies already update their submitted DBE triennial methodology to reflect the new IFR rule or requirement without conducting disparity studies? This was a question that was previously asked, but there's a follow-up question to that. It says if the agency has already had a disparity study conducted between 3 to 4 years ago, i.e. a disparity study that is not yet outdated, with this IFR rule, is this agency still required to have a disparity study?
Okay, so let's say you have a disparity study from 4 years ago that considered capacity. There is information that's valuable in the disparity study, especially in the availability database, that you know what the firms do, you know where they might work, you know what size of projects they bid on. All that's great information. What you don't know is who is a potential DBE, and our recommendation would be reopen that work and go back and contact the firms in the availability database that was a part of the disparity study and collect that, basically ask one more question, which is after explaining what DBE certification is, ask if they think their firm would meet the qualifications and would be interested in DBE certification. Without an additional piece of data, it's likely that the information in the disparity study, although useful in other ways, will not help you get to an overall DBE goal. So that's half of the answer to the question. And then I have the other slides from webinar 1. So let me just go to those. And fortunately, well, I have it in the first of these slides. The step 1 to get to a base figure, USDOT in the IFR changed some of the language for one of the bullets, but they didn't change the other acceptable ways. The approved ways are unchanged for using a DBE directory and Census Bureau data. We think that is not going to be ideal, but it is acceptable. The reason it's not going to be ideal is the count of DBEs may plummet. And we never thought that was a great way of doing it anyway, but it's in the rule. I mean, it's in the regulations as a way to get to a goal. If you've done that in the past, you could consider doing that in the future, the DBE directory and Census Bureau data way of doing things. Using a bidders list. We don't think that's going to work very well now, even though it's still on the books, if you will, because you don't know who was a DBE under the current definition in your bidders list. Your bidders list may show old DBEs, but not the new DBEs, or show minority women-owned firms, but not kind of a race-neutral way of looking at DBEs. So that second way of getting to a base figure is still on the books, still approved. We just don't know how you would use it because your historic data might not be usable. Data from a disparity study must account for firm capacity. The change in the base figure must account for firm capacity. That's what they added to the acceptable ways. And then using a goal from another DOT recipient, that's still on the books. We think that that's going to be almost impossible because of all the reasons we said before. They just, it may not have been a great idea in the past, and we don't know how other DOT recipients are going to develop these goals. And then alternative methods is the term that's in the regulations, and that didn't change either. So the short answer to your question is they didn't change much of the language about what are the acceptable means. So if you could follow a technique that had been approved in the past and develop the data necessary to do that, there's nothing in the IFR that would say that is not acceptable. We just have concerns about how much revised data or new data or current data you'll have to follow a method that you've used in the past, given how DBEs have been redefined.
Thank you. Okay, and we're going to go back to those two questions from that first set of topics there, and then we'll wrap up right after that. So first comment here is just go back to the answer to decertify firms that do not submit all requested documents by a timeline should defer to the initial Q&A. Can a UCP impose a deadline on currently certified DBEs for submission of the reevaluation documentation required under 49 CFR section 26.111? No, the regulation in that section does not provide a deadline for currently certified DBEs to submit documentation demonstrating its DBE eligibility under the new standards provided in the IFR. Firms that do not submit the necessary information, however, will remain ineligible for the DBE program until they submit the required documentation demonstrating DBE eligibility under the new standards. Okay.
I think that's right out of the IFR.
Yeah.
And so there was another part of that that we think is important, where they, in the FAQs from December 1st, you can set a date. And we think that that's critical to make all of this work, and maybe USDOT concluded the same, which is otherwise you can never get to the end of the reevaluation because you don't know when you will be done. There has to be some date that you communicate to those that need to reapply for certification, that, hey, you got to get it done by then so we can look at you, and it just, you need to have a date for them to know, how quickly do they need to move. So that's the way we see this. It's a bit tricky reading the language, but that's our stance on it.
Thank you. And final question, if the SBE program is a derivative of the DBE program, except that it is race and gender neutral, then how is it breaking the law?
I didn't say that. So we had anticipated the question of SBE contract goals, or just a small business program in general. The way the DBE program plans work is it's how an entity is going to meet its overall DBE goal and be compliant with the federal DBE program. That was true before October 3rd. It's true after October 3rd. Small business element is a requirement in the DBE program plans that can take different shape. One of the elements could be a DBE SBE contract goals program, for example. So we see that as something that is very specific. And so our question that we were answering is, can you just go do that now? Because, man, some of the folks that we've talked with, and when we look back in history, because this has happened before in the Ninth Circuit, where programs were suspended, DBE contract goals were suspended after the Western States paving decision in 2005. That's what USDOT told all the states in the western part of the country. And then so they stopped DBE contract goals. We've actually studied what happened when they stopped the DBE contract goals, and it wasn't pretty. So one of the responses could be, can we just do SBE contract goals right now while we're waiting to get DBE contract goals back? And our answer would be that yes, if it's already in your plan, but that needs to be approved. And the only way to have that be approved is you had it approved prior to October 3rd, or it's going to be in your new program plan and you'll get that approved in the future. But if you don't already have it approved, you can't get it approved right now. We don't see a way for you to say, please review this DBE program plan now. We don't know what our goal is. We're not done with reevaluation, but can you just look at this, USDOT? We think they would say, no, look at the IFR. You're supposed to do that after the reevaluation process is complete. So that makes you stuck if you don't have that in your plan now, or an SBE program element that's critical to the success and has something material to do with your contracting practices. We think that if you don't have that as a provision now in your plan, that you can't just go ahead and do that on your own for your federally funded contracts now. Now, maybe there's a minor thing where that's just not material, but if it's a major thing like SBE contract goals, we think that the approval from USDOT is going to be necessary. You either have it or you don't, and not having it means you can't do it now until it's approved.
All right. Thank you, Dave. I think we've addressed all of the questions that we've gotten from attendees. So I can talk briefly about next steps here. So we will follow up and send you all an email with the YouTube link. Again, please feel free to share this with your networks. And then you can keep up with us on LinkedIn and on our company website. We've got links there. For you all. But yes, please reach out for any additional questions. Again, we'll be contacting you and really appreciate everyone's time and all of the thoughtful questions during this follow-up webinar. Dave and Mara, any final comments?
Thank
Yes,
you all.
been food for thought. I will continue to think through some of these questions because they're very thoughtful. And as I mentioned, when I have more clarity on the Title VI the Title VI regulatory changes, I will share that with the Keen group, and hopefully that can also go out.
All right. Thank you, everyone.
Bye,
Have a great
everyone.
rest
Happy
of your day.
holidays.
Happy holidays, yes.
Take care.